Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. You're my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. You're my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything.
Hello, lovely people. It's another Saturday, and we are here in the community to bring you the community and the law live on BWTV and brought to you by BWF Solicitors. This afternoon, we're going to look at what we need to be mindful of. When they say they have given you notice to cancel your visa and your permission, what does it mean? And what do you have to do? Lawyer Charles Asma, our resource person and guest from BWF Solicitors, will be on hand to help us through it. The community and the law next.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, it's always a duty and a pleasure to be coming your way every Saturday afternoon, bringing you the community and the law. My name is Ulriku Frimpon, and I am going to be your host for the next 2 hours on the program, where we discuss all matters legal here on the program. It's live on BW TV, on Facebook, YouTube. It's also live on YouTube and Facebook at BWF Solicitors. So if you have just come on board, thank you very much. When you come in, we like the page, we share the page, and also invite others to join us. We're doing this courtesy BWF Solicitors, our trusted partners when it comes to the law. They are on the 4th floor of the other house, 214 to 218, Tottenham High Road, Seven Sisters in North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. You can call them, book an appointment, and send all your immigration matters to them, all matters of the law, interpretation, and of course, explanations. And for all updates and the rest of it, speak to BWF Solicitors on 0208 493 7340. The number again, 0208 493 7340. There are a number of lawyers who are so well versed in whatever they do, so they're inviting you to come bring your issues to them, and they will together help you do everything that has to be done. In emergency situations, you can call or text 077 127 61884. Now, having done that and done the housekeeping, I want you to get into the topic we're going to have to discuss this afternoon. Home Office, they often send notifications to people, and they say, well, we're going to cancel your visa. Home Office minded to cancel notice. Now, when we receive that, you would want to ask yourself, what is it? And how do I avoid potential cancellation of my visa? I know I'm speaking to the issue of so many people this afternoon because I know there are a lot of you in the community who have had this notification. We will be looking at that. And when you have received that, what do you do? I will obviously ask you to consult a lawyer where they sought to be able to help you through that. But what will be done? What are the steps? We will be looking at that. And I'm glad to say that BWF Solicitors has given us the permission to be speaking to Lawyer Charles Asma, who is going to be our guest and resource person this afternoon. He's going to take us through that. And he will share with us some experience of how successful they have been in situations like that. And then again, we will be asking you to ask questions, bring in your concerns, and all that. You can put that in the comment section down below, either on Facebook and or YouTube. So those of you who have joined us, I want to say a big welcome and thank you for joining us. You are so welcome. We're happy to have you. The family is good, and we all together in this. So if you joined us, let me see if I can welcome a couple of you before we go into that. The other time I told you I was going to do a special service if I was in church to a couple of people. I'll be doing that. Nanajiman has come on board. Thank you very much. He's asking us to share, and that's the message. Free legal education, he continues. Good afternoon, Lawyer Charles Osman Oruku Frimpon. Yes, good afternoon to you, Nanajima. You are the class prefect, and I know you're doing your job, and others will be joining us as well. So those of you who have joined us, if you new, click on the notification button so that when we put out content, you will be notified of that. Bernard Tete, thank you very much. Good afternoon to you as well. Let's see who else is here. Okay, so whilst we go on, when you come on board, we will be identifying you and giving you the welcome. Remember, if you are on and you have a question, you can text 07399208468, or you can call when the lines are active 0208 493 7345. Now, having done that, let's see what updates we have this week. And I know we'll go into our nugget and look at that. The 10-year ban and innocent mistakes. Making a mistake on an immigration application form can be very costly, where the mistake is interpreted by the Home Office as an attempt to mislead or deceive. The application may be refused and can lead to a 10-year ban on re-entry into the United Kingdom. In other situations, if the person already has a visa, even after some time, their visa may be cancelled and then the person deported. So it is very crucial that you avoid such costly errors or accidental mistakes. And how do you do that? Now, they're telling us, as we quoted from False Representations Caseworker Guidance, December 2023, you can do that by one, declare minor offenses when it comes to driving. Previous refusals or immigration history should be stated in your application. Please don't use false documents. They are costly. Then again, once you have completed your application, please go through it so that you can check one and the other and all the answers that you have given. And as I always say, use a lawyer and or a credible professional. Why do you have to do that? I know definitely I'll get Charles to highlight that for us. But if you want to avoid such costly errors or accidental mistakes where it could lead you to a situation where they will ban you for about 10 years, you would have to declare minor driving offenses. Previous refusals or immigration history should be stated. Don't use false documentation. Go through your application and make sure you've crossed your T's and dotted your I's, and use a lawyer and a credible professional to go through that. With that done, definitely you could be on a safe side and you would avoid any mistakes and a ban, of course. Having said that, I know that you are ready to be talking to BWF solicitors. They are on the number 0208 493 7340. Make sure you are in that. So, having said that, yes, the other time I mentioned to you that September is a special month for most of us in the community. And first of all, I want to say our own mother, the practice manager of BWF Solicitors, Madam Cynthia Brown, celebrated her birthday in the month of September. And we say that, Auntie Cynthia, your hard work and dedication are truly appreciated. We wish you a fantastic year ahead, a day that's gone. I know you enjoyed it. The rest of the year we should be full of celebration, and the year ahead of us. Until next year, same time when we celebrate you again, we wish you all the best. So, Madam Cynthia, thank you very much for being you, for being who you are, for leading the practice at BWF Solicitors. We appreciate you. We celebrate you. Happy birthday to you, Madam Cynthia. Even though, as related, we're celebrating all the special people in the month of September 2024. So, happy birthday once again. Now, the next one we had was our supporting staff, Abigail Appiajan. Abby also celebrated her birthday in the month of September. Abby, we wish you a fantastic rest of the year. We hope that your celebration and your birthday has brought you new things and all the good opportunities will come your way. We wish you success and happiness. Please enjoy the month, the rest of it. Today's 28th, yeah? Enjoy the rest of it and we celebrate you. Happy birthday to you, Abigail Appiajan. September has been wonderful. And we know that definitely everybody who is close and around you has had a joyous time with you. Happy birthday once again. Then we're going to the next one. And she started the whole of the celebrations in the month of September. It was golden for our very own Na Mayete. Na Mayete celebrated a golden jubilee this September, and it was marvelous. And I believe that we will all be doffing a hat to Na Mayete. Congratulations on your milestone. Now, we love you. We appreciate you. You serve the community with all your heart, with diligence, and of course, all the hard work is very much appreciated. Now, happy birthday. Happy golden birthday. May God richly bless you.
My blessing on now, favor fall down on me, goodness and mercy follow me every day. Everything when I touch for this life, anything when I want, she not my phone, oh, she not Porsche, oh, now me get on. If they're the dirty, don't mind them. If bottom belly come, me you buy them. My time don't come, yo.
Thank you all for supporting everybody we have celebrated this month. And if you celebrated your birthday in the month of September, you can put your name and some detail in the comment section down below, either on Facebook and YouTube, BWF Solicitors, BWTV, and we will bring it up and celebrate you. So to our celebrants, happy birthday to you. May the rest of the year be good, and may everything you wish for come to pass. The Lord continue to bless all of you.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes, with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. The program is The Community and the Law, and we're live on YouTube and Facebook and all other social media platforms. BWTV, BWF Solicitors. My name is Ulrico Frimpong. In the second part of the program, I'm bringing up my resource person, Lawyer Charles Asma of BWF Solicitors, our benefactors and our sponsors. And we're going to, first of all, take you through the update that I read and have a little more insight into that. Then we'll come to the topic of the minded to cancel notification that would have been sent to you. If you're in that situation, don't worry. Get ready. You can call in when the lines are active, 0208 493 7345, and Leasma will help you do that. So, first of all, Leasma, good afternoon, and thank you for joining us on the program. I know it's a busy Saturday afternoon, but yeah, you always do that. So we must show appreciation to that. Good afternoon once again. I think we're having some challenges with the link there. We will be bringing him up again. But before that, let me go through the nugget that I would want him to help look at: how to avoid a refusal and a ban, the 10-year ban, and the innocent mistake. So it means that people may make the mistake, but may not be aware that it could lead to some untoward circumstances. So, making a mistake on an immigration application form can be very costly. Where the mistake is interpreted by the Home Office as an attempt to mislead or deceive, the application may be refused and can lead to a 10-year ban on re-entry into the UK. In other situations, if the person already has a visa, even after some time, the visa may be cancelled and the person deported. It is therefore crucial that everyone avoid such costly errors or accidental mistakes by declaring minor driving offenses, declaring or stating previous refusals or immigration history. Um, Make sure you don't use false documents, and also ensure that you go through your application thoroughly. And then, as I always advise, use a lawyer and a credible professional to help you complete your applications. Let's say we'll have lawyer back online and have a very good and active. Yeah, yeah. I think we're doing well. Last one, thank you very much and good afternoon again.
Good afternoon, Brakoku.
Thank you
Good.
very much. Sometimes technology does us good, but it does us in as well. So don't worry about that. Anything we sincerely forgive you. Now I was talking about the 10-year ban that people imminently face when mistakes are made on applications. What kind of mistakes are we looking at here? And I know the guidance tells us what to do to avoid those, but with your expertise and knowledge, can you help us through it?
Right. Thank you very much. Yeah. So this is just the update. Now, we all apply to either visit the United Kingdom or remain in the United Kingdom. There are two sets. The first is your application,
Mhm,
and the second part is the document that you provide. So when you are applying, there's what we call VAF, visa application form, and that's a mandatory document. So every information you provide, they will ask you, did you do this yourself or you did it through a third party? So
mhm,
if you did it through a lawyer, you indicate. And if you did it through a helper, you indicate. And if you did it yourself, you indicate. Most people will say, I did it myself, unless a lawyer did it for them. Because even if a friend is doing it, they will put their own names there. The friend will put their detail, the person's own details there. So everything will appear to the caseworker that this came from themselves. Even if it came from a third party, it doesn't really matter because the application is under that particular name, the applicant. So we have all the information on the application form, and you have to be sure that you are satisfied. One thing that the law picks up is that whatever information you provide is as you wish. And so if it turns out to be untrue, it will be used against you. You also have documents you add or provide for assessment as part of your application. And so if it turns out that any of the document is not correct, it will be used
mhm,
against you. What do we mean? We are looking at all the things on the application form. Your name, of course, your name is your name. Therefore, if you've changed your name, you indicate. But crucially, we are looking at whether you have been previously married. Because if you have been previously married and you have, for example, divorced and remarried, and the authorities know because it has appeared in your application in the past, you have to indicate that yes, and you add the details they will ask for. If you have been refused a visa before, they will ask you, so you have to be truthful to that. If you are not sure about the date and all that, if you remember or you have a vague date, put the vague date there. But there's a table or a box which asks for description or explanation. In there, you can indicate that as far as I'm aware or I remember, I was refused in of December 2021. However, I am not very certain about the date as it has been some years now, and I do not have a copy of that refusal notice. Therefore, the date may not be accurate. But yes, I have been refused a visa before. In this case, you have put the authorities on notice that the date may not be accurate, but it is true and they can verify. That will not be held against you. But for example, if you say that you don't remember or the person didn't tell you about it and you say no instead of yes, then that is
So,
withholding information.
a quick question, maybe. We're talking about one being innocent, may not be aware of a mistake that has been made, is there any way I could explain so that it will be remedied rather than just having me punished straight away because the home office officer may think that I'm lying?
Thank you. But the starting point is that the application is yours. The law says that, or the rule says that, whether with your knowledge or without your knowledge. That
Hmm.
means if it wasn't your fault, then it is somebody else's fault, isn't it?
Yeah, obviously.
Good. Now, so there are two parts. So once we have established that there has been deception, or there has not deception, there has been misrepresentation somewhere, or there has been false declaration somewhere, or use of false documents somewhere. We want to now establish whether this was done intentionally or not. If it turns out that this wasn't done intentionally, then we say that it was done innocently. So that's
Hmm.
innocent mistake. And so how do you establish that it was intentional? If it is established that it was intentional, then it follows on that if it is intentional, there is intention to deceive so that you can get a visa.
Mm.
Your job now is to let them know that one, it wasn't intentional, and two, there's no deception here, so that you were granted the visa, or in order to get the visa. How do you show that this is not your fault?
Yeah.
That is where you say that one, because of your literacy background, you were not able to understand the questions. But not understanding the question is not an excuse. But that is something you can put forward in proving that you were innocent or you didn't do so deliberately. Or a third party helped you. Mind you, the law says that it doesn't matter whether you knew about it or you didn't know about it.
Okay.
So if a third party helped you, be it a helper, a friend in that sense, a family member in that sense, or an immigration lawyer or practitioner helped you, that's a third party. Then what you are saying is that if you had known about what they were putting on the form on your behalf, you wouldn't have sanctioned that. And
Okay.
therefore, it's been done without your knowledge. The law says whether with your knowledge or not your knowledge. So how do you? Then you argue that, hang on, if they had sought permission from me or sought clarification, I would have told them everything. Or I told them everything, but when they were taking no, they take yes for whatever reason. Then the person will have to provide, for example, a letter to explain that yes, they helped you and they made the mistake. It's not a mistake for anything, but it is as a result of X, Y, Z. So you put in that explanation, for example, to show that somebody helped you and the person did that, though not intentional. Or you did it yourself. You completed application form, but for whatever reason, you did not understand the question. Mind you, not understanding the question is not an excuse. However, you are saying
Yeah.
that if you understood it, you wouldn't have said yes instead of no, or no instead of yes.
Right. Now,
Now,
we look at. I know you were going to go to that. Maybe I'm preempting it, but we want to put every correct information on there, and you are talking about how to avoid those costly errors or accidental mistakes. Um, how do we go through these? You've given us five of those. How do we go through that? A driving offense, I may think that it's not necessary. What are some of the things that I'll have to tell them? I've got a parking fine. I drove through red light and I was fined. I paid it, and all those things. Do I have to tell the home office that?
the question will determine what to tell. So, on the form, there is a question that talks about whether you have been um, reprimanded, cautioned, penalty here and there. Once you read, you have an understanding that this is pointing towards that.
Mm.
And if, for example, you've had driving offense that led to a ban or disqualification, some people will have driving offense and they will go to court, magistrate court for it, and it will end up maybe going to the next stage or whatever. But whatever it is, if it is something that on the face of the application form, the question points to that action or incident, you have to declare. So the date and what happened. And they will decide whether that is necessary for the decision they have to make or not. I know some people will ask, I have driving offense, this and that. Do I have to declare? And as I said, it depends on the question there. And if the question is in line with that, please do not forget to disclose. Previous refusal, we have already mentioned that it's important that you remember and record that or include that on the application form. False documents, we have already mentioned that
Hmm.
if for whatever reason false documentation has been used to support your application, bank statements, pay slips, utility bills, and anything else, birth certificate, marriage certificate, divorce certificate, all these are documents that are potentially required depending on the type of application. And therefore, you have to ensure that the document is accurate. We also have the application itself. We are human, and therefore, whether you are doing it yourself or somebody is assisting, we make mistakes. So before you submit, you have to go through to make sure that you have unpicked anything that ought not to go with the application form. Then we have also using, and therefore the advice is that you have to seek help when
Mm.
necessary. If you need a lawyer, speak to a lawyer. If your pocket lawyer or your helper is the one that you are relying on to assist you, then make sure that before they submit the application, they give you opportunity to go through yourself so that you are 100% sure that the information is what you are satisfied with.
Okay. Now I know that the if unfortunately we get banned, is there any way we could get it reversed until the person spends the whole punishment period? Could it be reversed in any way, shape, or form?
So I'll give you an example. 2021, 2022, a
Hmm.
call came through and was from abroad. Hello, lawyer. We have a case. What is it? The child was a student. At the time, because of COVID, most of the students were studying remotely. Even though he had the visa to study or to travel to the UK for the university course, he couldn't travel. So he was participating or he had enrolled remotely. So he was a student. And they had written to him to say that they have realized that the visa was issued in error, in that upon further assessment of the document he provided, the bank statement had been identified to be fake. And so the visa is cancelled
Okay.
and now banned for 10 years. So we had to intervene. Now, this is the story according to the instruction.
Okay.
The child was then 18 years. The father was sponsoring the university education. The father got um, his assistant, boy, like as assistant, to get the bank statement for the son.
Okay.
The bank statement was provided for the son to add to his document for the visa application to be submitted.
Yeah.
The father was unwell, hospitalized. The boy gets the assistant gets the bank statement. Didn't want to disturb the master who is not well and hospitalized.
Okay.
They didn't also want to delay the submission of the application for the master's son,
Okay.
and therefore innocently concluded that if this is coming from the bank, then it will be accurate.
Was okay.
What was the issue? The issue they picked up was that there was a huge sum of money deposited once, and there was another one previously. And so there were only two transactions. And they concluded that this is potentially planted for the purpose of
Of
getting
the
a
visa
student visa.
application.
It
Okay.
sounds plausible. And on that basis, they refused the visa that had already been so cancelled, refused, and banned, even though the visa had already been issued.
Okay.
So our conclusion then was that, right, if this is the instruction, it appears that the child or the student did not submit this deliberately or intentionally, and there is innocent mistake somewhere.
Hmm.
So we argued that this is a child, 18 years. He has his life ahead of him. He has education, aspirations. One. Two, this is a father who cares so much. And at the time, he was hospitalized, and therefore he did not have the opportunity to even question the bank statement from the bank. The bank writes a letter to say that yes, this bank account exists and the payment is accurate or the transaction is accurate.
Hmm.
It is not about the middleman, the assistant of the master who helped. Now it's about the boy himself to prove. And so we concluded that much as it is true that this cannot be 100% accurate, it is innocent on the part of the applicant student whose visa is being cancelled and he being banned 10 years. And therefore, they have to consider the fact that one, there was no intention to use false document on the part of the boy, the applicant. And two, there was no deception on his part to be able to get a visa. And so they have to reconsider the decision and give him opportunity. So after administrative review process with strong argument, they came back and said that we have considered the representation and we are satisfied that the mistake was innocent and therefore, yes, the visa is cancelled, refusal is reissued, and this time it is left at paragraph 9.7.1 instead of 972, which comes with a ban. And so, end of story. So then I told them that we have it's now positive in that having been cleared that there's no deception, you can apply again. They went in to apply again, and the child got the visa and came to the UK to continue his studies after COVID.
So then it goes with the last bit of the list you give us, that um, use a lawyer or a credible professional to help you in this, in the sense that had it not been you knowing how to argue this and analyzing and critically tearing them apart and putting them together again, this person would have been banned for 10 years. So then I can confidently say that if in doubt, always use a lawyer.
It is very, very good. It's advisory.
Hmm.
Even though people have their choices, it is important that they consider this.
Right. Well, thank you very much. So definitely there is a way to avoid the refusal and the ban. And even if it's in place and innocently you made a mistake, there is a way to make your argument and possibly get it rescinded, that decision I mean. So I will go from the bottom and say use a lawyer and a credible professional. Make sure you go through your application. Even if you can read and write, get the person who is representing you to go through it again and explain to you vividly, point by point, to say that for this we answered that, for this you provided us this information, this is what the answer we gave. Don't use false documents. Previous refusals or immigration history should be stated. And please, if you have any driving offenses, no matter how minor they are, declare them. In that situation, you can avoid the refusal and or ban. This is a community and the law. Ezekiel Johnson, thank you very much. He says BWF Salit says Abaneke. Um, thank you very much. Thank you for joining us. We're live both on Facebook and YouTube. And this afternoon, we're looking at Home Office minded to cancel notice, what it is, and how to avoid potential cancellation of your visa. Charles and Mary also says BWF solicitors, hashtag no size. We take a break, and when we come back, we're looking at this particular topic that I mentioned just a moment ago, and lawyer Charles Asma will be helping us through that. We are coming live to you from the studios of BWTV, and we're brought to you by BWF Solicitors, our trusted partners when it comes to the law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. If you have just joined us, we are live on BWTV, and we're bringing you the program, The Community and the Law, this afternoon. As usual, by courtesy of BWF Solicitors, we're bringing you another very interesting discussion, minded to cancel or minded to refuse. What is that? How to avoid potential cancellation of your visa. A resource person and guest for this afternoon is Lawyer Charles Asma, a solicitor at BWF Solicitors. BWF Solicitors, 4th floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters in North London. Call them 0208 493 7340. And you can send an email to admin@bwfsolicitors.com. You're live on Facebook and YouTube at BWF Solicitors. What is it that we're talking about? Leasma, minded to cancel or minded to refuse? To refuse what? The ordinary person would ask.
Right. To refuse what? And that is the essence of this conversation. So,
Right.
we have touched up on the update, which actually is a good starter to this conversation. So, we are now bringing you the main course, which is the topic for this evening. Um, Minded to refuse, minded to cancel. Today, it's all about minded to cancel, or the case study is about cancellation of existing leave. What do you have to do, what it is in the first place, and how do you avoid this happening to you? We are going
Mm.
to do this by exposition of what the law is and also looking at practical um, aspect of it, how it works in practice in terms of getting it um, rescinded or getting the cancellation stopped. Before that, may I humbly invite producer to share with us the the guidance that the Home Office requires staff to use, please. So cancellation and curtailment of permission version 6. And please, we can go down a little so that we know the date this was issued. So issued to Home Office staff, caseworkers, 15th August 2024. So this is just barely a month ago. And the content tells us what is contained therein. If you go to page 19, please. So if you go to page 19, tells us about mandatory and discretionary cancellation grounds. So if you look at this, we call them mandatory in the sense that if it turns out that there's fake documentation or deception used to get the visa, then the person will fall under mandatory. If it turns out that it was innocent, the person will fall under discretionary. Either discretionary or mandatory, it calls for cancellation. And so the caseworker is required to be careful. The word is careful because you are dealing with somebody else's life as far as immigration status is concerned. And it's all about allegation, and therefore they want to be sure that they are not just relying or acting on flimsy excuse or um, flimsy point or view or allegation that something has happened. If you go down, please, scroll down to 97, if it's there. Okay, good. So 973, stay there. Making of false representation, submission of false document or false information, and failure to disclose relevant facts in relation to or in support of an application. So 9.7.3 is cancellation. 9.7.1 is refusal. Now, use of deception in an application for permission to stay. So if there has been deception and it is found out later after visa is issued, you will be told and the visa will be cancelled. Failure to comply with condition of permission to enter or stay. Again, 9.8.8 is about the condition itself. The conversation is not about the condition, but the fact that something might have happened and they feel that they want to cancel. Well, that condition will be that you came in as a student to do 20 hours, for example, and you ended up doing more than 20 hours in a term during the term. You came in as a visitor and you ended up working even though you said you were not going to work. You came in as a skilled worker, for example, and there's no work. And so the condition has changed. So anytime you apply, you are given a visa to enter the UK or remain in the UK, and the condition of your stay or entry changes, you are liable under 9.8.8 for cancellation. Now, where there has been issue to do with document used, we said that that would be 9.7.3. So this is under immigration rules 2.5, student visas, skilled workers, and so on and so forth. Now, under EU provisions, there is a paragraph called paragraph A3. Paragraph A3 looks at cancellation of pre-settled or settled after the person has been granted, and that is under Appendix U to the immigration rules. Producer, please go down a little further. Right, if you go just a little down, let's see the next. Okay, stay there. Part 9 grounds for cancellation. So we'll just touch up this briefly. You must review and familiarize yourself with the wording used in part 9. So in part 9, there are two words. One is may and the other is must. So it says that if the person used false documentation with a view to obtain the visa, or false information with a view to obtain the visa, and it is later found out, the visa which has been issued must be cancelled. And that's mandatory cancellation. If the person did that, but there was no intention per se, and so there's no deception, then the visa may be cancelled. So there's a discretion, and there's also mandatory aspect or compulsion. So the caseworker has to be careful to understand the law itself as to not to mix may and must. So this is the standing or the starting point in terms of the rules, and the caseworkers are required to follow this. So our conversation tonight is you have received a minded to cancel notification. The
Mhm.
rules say that once you suspect that the applicant used deception or used misrepresentation to obtain the leave, whether leave to enter or leave to remain, you have to put them on notice to ask them to explain themselves to be sure that your allegation is made out before you go ahead to act. And therefore, if you don't put them on notice, you are wrong. And therefore, there will be procedural impropriety. Now, minded to means that warn the person, invite them to give their side of the story, to confirm the allegation or to deny with evidence. Once you receive that letter, your job is to respond. If you don't respond, they will go ahead to cancel. Once you respond and they are happy or satisfied with your responses, they will stop the cancellation and give you back what you have already. Today's conversation is about minded to cancel. So we have a case here where
Mhm.
our case study person or individual or subject had minded to cancel notification. We had to then go through the process.
Yeah, just hold your thoughts right there before we go to the case study. If the word minded comes in, uh, is it saying in the ordinary person's language to say that we have the intention to cancel your visa, so come and answer questions or we will do it? And if that is so, how long do they give you?
Thank you. That is the case. So they have to warn you literally.
Okay.
So come and explain because this is what we suspect. Tell us if we are wrong.
Okay.
If you're able to prove to us that we are wrong, then we won't do anything. If not, your visa will be taken away from you within the rules.
Yeah.
How long? Usually 7 days, 14 days. If you're in the UK, it's 14 days. But the caseworker has a discretion to give you, because first, again, even though there is evidential flexibility, this goes beyond evidential flexibility. So
Okay.
evidential flexibility is usually 7 days. But with this one, where there is intention to cancel your visa, it is as if you have been refused and you are asked to go to the next step. So usually 14 days that you are given, but they can give you any days or any number of days.
So could it be more than 40?
Usually 14 days. And so if they're going to give a maximum, it will be 14 days.
Okay, all right. So then let's go through what it is that they will do at the point that I stopped you. We're going to pick up an example and look at that.
Thank you very much. Yes. So the example or our case study here, producer, please, if you could assist us.
Okay. So this is a forwarded email application update from Home Office Atlas. That is the Home Office. The to the person was to. We have redacted that for GDPR purposes. The name is there. UAN reference is also redacted. Your EU settlement scheme limited leave to remain, also known as pre-settled status, may be curtailed. Um, so it means that this one they would want you to answer before they curtail it. So if your answer is not satisfactory, they curtail it. But if it was must, then obviously then it was mandatory. There wouldn't be anything to do about that. Could that be the case, lawyer?
So within the spirit and letter of the law, yes. Whenever they say may, that's discretionary. But if you are warning somebody, then you cannot use must.
Okay.
Because the reason for warning the person is to give them opportunity to tell you what you want to hear so that you can exercise your discretion.
Right.
And so the
Okay.
right wording will be may. You may lose it if you don't do that. So it's a conditional statement. If you do
Okay.
that and they're happy, it will not. And
You will
therefore,
not.
this will come as we saw earlier, the discretionary point 9.73 that we looked at and associated paragraphs.
Right. Okay. I'll continue to read. The reason here is that you were granted limited leave to remain in the UK on the 22nd of March 2022 as a non-EU dependent of an EU national under EU settlement, valid until 23rd March 2027. Paragraph A 3.4 of Annex 3 of Appendix EU to the Immigration Rules provides that limited leave to enter or remain granted under Appendix EU, also known as pre settled status, may be curtailed where it is proportionate to curtail the leave, where curtailment is justified on grounds that, in relation to the relevant application under Appendix EU and whether or not to the applicant's knowledge, false or misleading information, representations, or documents were submitted, including false or misleading information submitted to any person to obtain a document used in support of the application, and the information, representation, or documentation was material to the decision to grant the applicant leave to enter or remain under Appendix EU, or curtailment is justified on grounds that it is more likely than not that after 23 hours GMT on December 31, 2020, the person has entered, attempted to enter, or assisted another person to enter or attempt to enter a marriage, civil partnership, or durable partnership of convenience, or the person ceases to meet the requirements of Appendix EU. So this more or less is the conditions are stated in the law, and the quoting that to support what their suspicions are. Is that correct, lawyer?
Yes, so let's go up a bit. I want us to understand the first, second, and third points. So the first one says curtailment is justified on grounds that, in relation to the relevant application under appendix issue, and whether or not with applicant knowledge. Remember, we said whether you knew about it or you didn't know about it is not the question.
Mm-hmm.
What is important to the caseworker is that false or misleading information has been used or false document has been used. And in this case, submitted to any person to obtain a document used and the information representation documented was material to the application. So you see that number one, here they didn't say that if you go scroll down just a little, just one step down, and the decision to grant the application was relevant. So in this case, it says the document was material. So if the document was material, so that without the document, the person would have been refused. It could be that the person did it innocently, could be that the person did it deliberately. Now, whether it's going to be may or must is what is the lighter note or the more serious note. So if you look at this, we can say that well, this could be serious, could also be lighter because the person used certain things, information or document, um, and here the intention is not stated, but it says that whether the information or the document is relevant to the application. So discretion will be considered here. If you go to the second one, the second point, it says that assisted another to enter or attempt to enter a sham marriage or marriage of convenience. Is this a lighter note or more serious note?
A serious note because you engaged in deception, isn't it?
Exactly. So even though there's no use of deception here, it goes to show that there is implied use of deception because you assisted or attempted to enter into sham marriage. The word used is not sham, but they say marriage of convenience, which is also sham marriage. And the third one, if you look at the third point, what does it say?
The person ceases to meet the requirements of Appendix EU.
Right. So this is where there has been, for example, marriage has ceased. And if marriage has ceased, what should happen to your visa, which was obtained as a result of the marriage? It should
Um,
also cease, right?
it doesn't really stand anymore because you came on that and the marriage is not more, isn't it?
Exactly. So if the marriage is no longer, then the visa should be no longer, unless there are extenuating circumstances. But with this one, the moment the caseworker suspects that the marriage has ceased to exist. Not that it was a sham marriage, but they have divorced. If they have divorced, what possibly they are thinking is that if they had divorced earlier or the marriage did not exist earlier, this visa wouldn't have been granted in the first place. Now let's jump and go to the last. I have, yeah. So I have been go to what happened. I have been made aware.
I've been made aware that your relationship with your sponsor has now broken down as you were granted limited leave to remain in the UK based on your relationship with your sponsor. This means that you may no longer meet the requirements under the scheme as you cease to meet the requirements of Appendix EU.
Right.
Therefore, I'm considering whether it's appropriate to curtail your limited leave to remain under Annex 3 of Appendix EU.
Okay.
It
So
continues to
stay
say
there for
before
me,
making a
but
decision.
I want us to be interactive. Now go up. Producer, go up to the third bullet point. Yes, stay there. We have bullet point 1, 2, and 3. So which one is being referred to for the cancellation to happen? Is
The
it
person ceases to meet the requirements of Appendix EU, isn't it?
very good? So this has nothing to do with sham marriage, has nothing to do with use of false document or information, but is to do with the fact that it is suspected that the marriage is no longer. Now, this is
Mhm.
somebody whose husband has reported that the marriage is not there. And on that basis, the officials have said to this um, holder of the leave that we are doing this because we have received information that the relationship is broken down. But there is also, remember, there is also the retention of right where the relationship has ceased. But when that relationship has ceased, there should be divorce. This one, we are not told that there is divorce and therefore
Okay.
potential separation. Are you with me?
Yeah.
So if there is separation and divorce has not commenced or ended, then they will say that if the relationship is no longer there and there's no supervening event, which is divorce or ongoing divorce proceedings, you do not qualify under retention of right. So he realized that they didn't even offer this person retention of right. So they went
Okay.
straight. And what did they say? Please go down.
Um, so the next paragraph down. Okay. Therefore, I'm considering whether it's appropriate to curtail your limited leave to remain under Annex 3 of Appendix EU. Before making a decision, I'm contacting you to give you an opportunity to respond to this allegation and provide any further information or evidence that might show reasons why your limited leave to remain should not be curtailed. The curtailment of your leave is the only decision that is under consideration at this stage. You'll be notified of the outcome of this consideration, and if a decision is taken to curtail your leave, you will be notified of your appeal rights.
And finally,
And finally, you must provide any information or evidence within 14 calendar days of the date of this notice. If you require additional time to provide information, you must provide your reasons and any evidence for this request to um, that reference as soon as possible. I do
right.
not receive a response from you within the time scales provided, I'll make a decision based on the information and evidence currently available. So if you wish to respond by email, please send it to this email down here.
Right. Thank you, Brakoku. So let's go up to the beginning of this resource, please. Up, producer. So date. What is the date?
The
Right.
date is the 2nd of September 2024. So 14
Okay.
calendar days will bring it to the 16th of September 2024.
Good. So we took the instruction from this person. They called, panicking, and they had about 5 days to go. So we had to act within the remaining days. And we're very minded that deadline was 16th of September. So it's always crucial to have the deadline in mind. But they're also taking the box, making sure that the midnight is up for the next day, and they will say you didn't respond, so your visa is gone. So what did we do? Producer, move to the next resource, two, please. So resource two, we had to respond. So we said, dear sirs, and this is just the introduction, we are minded to cut off certain things. We now act for the above applicant in her matter. We attach a letter of authority from her and regarding your email of September and respond as follows to your minded to cancel notice within the principle that is within the rules. And we detailed everything. The cancellation, we pointed out that the intention to cancel is under point 3 of the rule of Appendix A 3.4 of Appendix U, paragraph A 3.4 of Appendix U. And it says that the relationship has ceased, and that is why you intend to do this. So we had to explain why the relationship had not ceased and why whatever has happened has happened. Mind you, the Home Office did not provide information as to what the person said to them.
Mhm.
There wasn't an interest at the time. So the main thing was to deal with the situation. So we quoted that you are not worried about anything, but your worry is that the relationship might not be there. And we are responding this way or as follows. We took instruction from this person, and the instruction was actually this. The person comes into the UK with 6 months and upon arrival gets 5 years pre-settled through the husband.
Mhm.
Everything is there. They were living together. 2 years later, she conceives. Husband says that, no, I'm not interested in another child. So take it out. She says, I can't take it out. Well, if you can't take it out, go back and I will make sure you do. What is happening here, Brakweku?
That's our domestic abuse then.
That's threat, isn't it?
Yeah.
And blackmail.
And blackmail as well, yeah.
Yeah. So we had to point it based on the instruction. So in our
And
argument,
obviously, it becomes more serious because this is a person who's pregnant.
well, no. We are responding now, and this
Oh,
so
okay.
the
So the person is giving birth anyway.
is
Okay.
that the child was born in 2022.
Okay. All right.
So we are responding now, and you see, after so many
There, there,
years,
there
they
could
come
be
back
there
to
could
say
even
they
be
are canceling the
postnatal
thing.
depression anyway.
So our argument is that look, our client comes in to the husband, happy, living together, becomes pregnant. Husband says, I don't like it. She says, I like it. We have to keep it. Then on and on and on. If you don't listen to me, I will deal with you and I will make sure you go back. So if it turns out that somebody has reported him to go back. Isn't that a threat carried?
Yeah, this the story carried out.
Exactly.
Yes.
So we told them that. And we said that, look, under domestic violence rules, the law seeks to protect victims, not the perpetrators. And so, if you are going to punish anybody, punish the perpetrator, not the victim. And we left it for them to decide. And we told them that if they don't, we then move to the next step. They came back. So, producer, move on to the next response. So here they came back to tell us to provide certain information to them. So this was
Mhm.
22nd, this was 24th of September. So we had to respond to them. So we told them that they have requested further information and we have given it to them. No need to tell them or to show you here what we discussed with them because that is not
Yeah,
relevant to
obviously.
the
Yeah.
conversation. So they came for more information and we responded. And the information was to do with the child in question because the response was that there is domestic abuse going on and it stemmed from the pregnancy up to the point when they have picked up that information and they are deciding to cancel. So after this response on 24th of September, they came back again. Producer, what did they say? Right.
Please find. Is this the one? Yeah, Home Office at
Yes. What's the date?
last
What's the date here?
is the 26th of September 2024.
Okay, go ahead.
It says, find below information relating to your clients. Please ensure this is passed to your client immediately. Kind regards. Your EU settlement scheme limited leave to remain, also known as pre-settled status, remains valid. I wrote to you on the 2nd of September to tell you that I was considering whether to curtail your EU settlement scheme limited leave to remain, also known as pre-settled status, under Annex 3 of Appendix EU to the immigration rules because your relationship with your sponsor had broken down. Thus, consideration was made in line with Annex 3.4C of Appendix EU to the immigration rules, which states a person's limited leave to remain or enter granted under this appendix may be curtailed where the Secretary of State is satisfied that it is proportionate to curtail that leave where the person ceases to meet or never met the requirements of this appendix. You responded on the 15th of September with subsequent responses made on the 20th and 24th to my further write out on the 20th of September 2024. After investigating your case and reviewing the evidence available, I'm writing to inform you that I've decided not to curtail your limited leave to remain. This is because you have provided sufficient evidence that satisfies the criteria for maintaining your current status. So,
Full
what
stop.
does this mean to you?
Yeah. Full
You
stop.
continue to hold your EU settlement scheme limited leave to remain, also known as pre-settled status, and your existing entitlements are unaffected. You don't need to do anything further. Congratulations, Laura.
Yeah, so this is what we do at BWF Solstice. We review critically, evaluate painstakingly, and act professionally with a view to getting the best for the client. And this is an example how to deal with a minded to cancel notice from the Home Office, what it is and what to do to avoid the potential cancellation.
Well, then it's a bit technical because when it is that if I did it on my own and they wrote to me to say referring to this appendix EU and this section of those regulations and the law and the rest of it, it would become quite difficult for a layperson to be looking at this and of course have the capacity to be thinking through some of these things. So back to our nugget, for instance, the last point that we said, that speak to a qualified lawyer or a qualified professional to do this for you because I don't think it is something we can easily and readily do on our own lawyer.
Yeah, I agree with you, Rakoku. But a question to ask is this: who is the law for?
Well, it's for everybody. Every
No,
citizen.
in
Yeah.
terms of working with it.
Oh, well, it's for lawyers. I often
Listen,
say that it's
the law
always
is for the
best
lawyer.
for a
And
layman
so,
to give his work to an artisan to do for him or her.
and so if they are going to cancel you on the basis of the law, then you have to use the same law to deal with it with the view to get them to change their mind. So
Sure.
if you did it yourself and you got it wrong, or they thought you've gotten it wrong, and now they are pushing you harder with the law, you cannot afford to play with it yourself. You
That's right.
need someone who can interpret the law. And so, rather than all the 3 points, all we needed to do was to narrow it down to what they are referring to. They are saying the marriage has broken down.
Okay.
If they said there was divorce, we would have told them that if there's divorce, that's a supervening event. So the person qualifies under retention of right.
That's
They
right.
would then say that then they have to make a new application. They would have done another application for this person. But they said that the marriage is broken down. The law says that if the marriage is broken down and there's no divorce or there's no divorce proceedings started,
Hmm.
it's more or less like separation. Then if there is separation from the person, then you must separate yourself from the visa as well.
That's right. Yeah.
And that is what was used against this person. And we said that you don't know what we know about this person.
About this
And
person.
this is what it is. And now you, being the caseworker and a human being, use the information, listen to the story, and tell us if this person should be denied or rather supported.
So minded to cancel notice when it comes in is a technical and a legal thing. So you deal with it as the law says and answer, narrow it down to the reason quoted from the law to deny you or threaten to cancel your visa or your status. And the advice is speak to people who work with the law and they will help you. That's what we're doing, and that's the empowerment we bring you on the program, The Community and the Law, brought to you by BWF Solicitors. This afternoon, we are looking at Monday to cancel notice, what it is, and how to avoid the cancellation of your visa. You've got your questions, you've got your concerns, any comment, send them down to the comment section below, either on Facebook or YouTube, BWF Solicitors and BWTV. And we are live on the program, The Community. And the lawyer resource person is from BWF Solicitors, lawyer Charles Asma. We saying thank you to BWF Solicitors. And when we come back, I will drop in the scenario question and see if you can bring out the wealth of knowledge you have acquired and then also take your questions as well. Stephen Jesuko, for the number to call is 0208 493 7345. I take the number again, 0208 493 7345. Or you can send a text or WhatsApp to 07399 208 468. Let's say thank you to BWF Solicitors and we'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Well, thank you very much for sticking around. If you stuck around for this long, I believe I need to say a big thank you to you because one, you have enjoyed it. Two, you have shown faith. And I want to remind you that at the end of the year 2024, there will be the Senior Partners Appreciation Reward. And those of you who shared the most, those of you who stayed with us longest, will be considered and one would win the prize as well. Remember, our quiz competition will be coming. The traditional end of year quiz competition from BWF Solicitors will still be coming. So stick and stay, and let's keep sharing knowledge and opportunities here on the channel. Now, before I go back to Lawyer Charles Osma, thank you very much, BWF Solicitors. Let's look at what we used as our update and our nugget. Then I'll bring you a question for you to consider. Then after that, we'll take your comments, your questions, and Lawyer will be helping us answer them. Making a mistake on an immigration application form can be costly, where the mistake is interpreted by a Home Office as an attempt to mislead or deceive. The application may be refused and can lead to a 10-year ban on re-entry to the UK. In other situations, if the person already has a visa, even after some time, the visa may be cancelled and the person deported. It is crucial, therefore, that you avoid such costly errors or accidental mistakes by one, declaring minor driving offenses, previous refusals, or immigration history should be stated as the second point we're looking at. The third one says don't use false documents. Go through your application thoroughly to see that every question is answered, and as much as possible, use a lawyer and or a credible professional. So, okay, now let me test you on this to see if really you would be able to give a credible answer to our friend here. Kwesi, use an agent to apply for a certificate of sponsorship as a skilled worker in the year 2023. He was granted a 3-year visa as a plumber with Yintumi Construction Limited in the UK. In June 2024, Agosti received a letter from the Home Office that his visa would be cancelled unless he provided an explanation of why he used a fake university degree certificate. Akwesi said he was not aware that the agent used a fake certificate. He paid the agent to take care of all the processes and only provided his passport. He says he's innocent and therefore would plead with the Home Office. Now let's look at this. What are the chances of Akwesi convincing the Home Office that he's innocent? Would it be that he didn't know about the offense, so it is an innocent mistake? Would it be that the agent made the application so Akwesi is not at fault? Or could it be whether or not Akwesi knows that the false document was used, he is at fault? think through this and we'll come to answer that. Okay. So let me go to the platforms. Lawyer is still around. Lawyer Charles Osma, a resource person, is still around. So we're going to pick some of your comments. The lines are active. 0208 493 7345. You can call in and speak to the lawyer, or you can send a text to 07399 208 468. You can send a WhatsApp message as well, 07399 208 468. Now, I think just as we started, we had Kofi Akubia sent this, and it says, my friend put in an indefinite application based on the parent route. The Home Office has requested for information about the British citizen child in the form of evidence to prove he still has parental responsibility. Unfortunately, the child involved has passed on to glory. What can he do in such a situation? And as we had a discussion going on, we had a senior partner bring in this response. I know, Kubia, you may have seen it, but for the benefit of people who would have read your question, let's see this answer. Kofi Kubia, so sorry to hear about your friend's child. He needs to be open with them, and if he has been on the 10-year route, then he can use a 10-year lawful requirement to apply for settlement. Last one, I think maybe we can expand this a bit more to what our senior partners brought. The 10-year lawful requirement, what does it say, if you would help us? I think your mic is muted, if you could help us.
Thank you very much. And
Yeah,
we are
sure.
grateful to this senior partner for sharing the view and response. And so the point with 10-year lawful residence in the UK is that if you have been in the UK lawfully, in other words, there is no break, and you've been on a visa, different types of visa, except of course the the graduate route visa, that one doesn't count, but anything else should count. And so, of course, visitor's visa doesn't count either. But if you have been lawfully 10 years in the UK, so let's say our friend, two and a half, two and a half, two and a half, or whatever it is, we haven't asked him which route he was on, whether
Mhm.
EU or non EU, but he's due for indefinite. Because he's due for indefinite, he can say that whether my child is around or not, I have done 10 years lawful residence in the UK. And the law says that if I have, I should be granted indefinite leave to remain. So they should look at that as opposed to the challenges I am facing. Then we have to then explain to them, quoting the law, and again, imploring them to consider the person's circumstance, and more so the fact that they've been in the UK lawfully for 10 years for them to be granted. Um, we don't usually experience this. When I read that this bit from our friend earlier on the platform, I was thinking, wow, we don't usually have these things happening. And the EU, there wouldn't have been an issue, but it appears that this is not a EU application. If the child is not there and you want to remain in the UK to be able to be with the child, then they say prove that you are still in the life of the child. Again, people lose parental responsibility in the course of their lives with their respective children. And so they want to be sure that the person is still a qualifying parent. But hang on, this is indefinite leave to remain. And to qualify, I have to show that I have been continuously resident in the UK, lawfully resident, with no imprisonment, with no break, and so on and so forth. Then that should be the focus. So we have to, in this case, our friend can go ahead and explain to them what has happened and point them to what they have to know. And they have to consider that to grant him the indefinite leave to remain.
All right. Thank you very much. The next one is from our friend Anetia Hine. He's put that on the platform as well. Anetia Hine sends, during the visit visa application, an applicant's mother's date of birth was correctly entered as the 1st of January 1950, the correct date of birth. During entry clearance, a typographical error was made about the same mother's date of birth to be the 1st of June 1950, which is wrong. The error is just the month, January to June. Now, in naturalization application, the correct date of birth for the same mother was entered as the 1st of January 1950, but no statutory declaration was submitted to explain, no explanation submitted in a cover letter. All requirements are met for naturalization except this error. Nana wants to know if this can affect the decision of the naturalization lawyer.
Right. Nana, thank you for this. We are not able to say yes or no, but we are able to offer some clarifications to this and what the caseworker may wish to find out. The reason is that because it's a material information, if they already have his or her record, they may ask the person's date of birth on that application was this, and here it is quoted as this, and now it is this. So which is which? Some caseworkers may look at it and say, right, the first was January, the second was a mistake, or was June, and the third is January. It goes to show that maybe the second one was a mistake, and that's why they have fixed it in the subsequent application and just gloss over it and conclude on the basis of the other requirements. But you may meet another caseworker who will be very pedantic and say that, hang on, come and explain why this and that. Or they may just take issue with that. They didn't explain, they didn't give any context, and it's already gone. If it's already gone, there's nothing you can do. So you have to wait for them. But as to whether they will decide yes or no, nobody can sit on radio or in advisory position to say yes, they will not consider or they wouldn't do anything. So I would say let's wait for what they come back to say. We just hopeful that they won't pick issue with that. But if they do, they may ask you to clarify. Of course, you will have recourse in law to do the next thing, as in challenging that bit. So we wait and see. If you still feel that you want to send an explanation to them, you can do that by emailing them to say that we needed to have done that, but we are just addressing this, and that, and this is the situation. Yeah, but again, whether it will go to be added to your application or not is another thing. So I would say wait and let's hear from them.
Well, I want to recognize Colin Sofori watching with us, Amos Abibio, Bobasari, thank you, Malu, congratulations, thank you for watching with us, Steven Jensuko for Steve, thank you, Sandra Pokujun for thank you, Cynthia Julie Annan, thank you, Auntie Cynthia, happy birthday again to you. We love you from the whole family. Davis Saputra, thank you for watching. Fad Salu, Nana Frimpong, Kevin Asamoah. You say good afternoon, Lawyer Asamoah and Reku. Thank you. Kapokea Kufu, Sambath, and Wumpini Adam. And you also send your greetings. Good evening. One question here. Good afternoon, Lawyer. Um, I am here as I think it should be us. I'm here as a skilled or I'm here on a skilled worker route. Maybe uh, you had a typo. My employer cannot even give me 20 hours shift per week. What can I do? Will this affect my permit being revoked?
Thank you very much. So the rules under Appendix Skilled Worker say that when there is a change in circumstance, the employer must inform the home office, so home
Mm.
office will take action, or the employee must inform the home office so that they take action. What would they inform? We see that there has been change in circumstance in that the employer has ceased to have a job for this person, and so the employer must tell them that something has happened. This person will be given 60 days to find another employer, otherwise they lose their leave to remain in the UK. What can I do? You can look for another employer so that you can switch from this existing employer to the new one you will find. Would
You
that,
mean if you say another employer, is it any area of work or it should be within the same industry?
as long as you are able to find a new sponsor, it doesn't really matter. What is important is that it falls within the industry requirement, or if it is outside the occupation shortage, you still have sponsorship from this new employer or potential employer. And
Okay.
because your leave is exempt or hasn't expired, you can move from existing employer to new one and switch your leave. Would
Okay.
this affect my permit being revoked? Yes, there is risk if it is found out that there has been change in condition of your leave, which is to work for this employer for the hours you were contracted for.
Okay. Well, your comments both on Facebook and YouTube, we're picking them. Rufcon on YouTube says, would IHS fees be paid if a child has one British parent by descent and the other parent on spouse visa when applying for indefinite leave to enter from outside the UK? Would IHS fees be paid?
Right. Normally with IHS, when the child is when the application is being made for a child, you is this for if a child has one parent. So I suppose this is a child application, right?
Hmm. So
Or
one
maybe
parent being British by descent, other on a visa on a different route, spouse visa, really.
so this is for uh, okay. So if a child has one parent, so a child has one okay, and another parent when applying. So this is the child applying, isn't it?
Hmm.
That applies. So the applicant is the child. Children applications normally with indefinite leave to remain, there isn't IHS because the person is coming in to settle, not to stay and move on to the next stage. So, however, even if they say that the child must pay an IHS, they won't request the payment until the visa decision is made with a view to grant. Then they will ask the child, of course, the parent, to pay for the IHS. So what I would say is that if this application for the child, don't worry. Put in the application. If they think that the child must pay IHS, they will come back to ask for the IHS fee. At that time, you know that the visa is a done deal and you happily go ahead to pay if you have to.
Yes, the lines are active 0208493735, or you can send a text to 07399208468. You can send a WhatsApp message to that line as well, 07399208468. So those of you who want to call, the lines are active now. You can call in. Now, Laura, before any call comes through or we pick up any comment, now, when we were looking at the minded to cancel, particularly the case you used for our discussion, this case lawyer, case worker, so to speak, suspects that the marriage has broken down. Now, you were able to provide evidence and then mitigated the situation and got the visa not cancelled. Could the other partner, who probably and possibly reported, still contest and provide evidence to say that I still insist that this person is not giving us the correct and accurate information?
How will this person also contest that the instruction or the story by this spouse is not true, that there is domestic violence?
You know, somebody
How will
who
he
somebody
say that?
who is so bent on quote and unquote showing this partner.
But then the question is, he brought the lady to the UK because the lady is the spouse,
Right.
married her, applied for her, and she entered, joined her in the UK, actually gave her everything that needed to be used to support the application. So if it was true then, what has changed?
Well, that's for him to prove, really.
Exactly. So let's wait for him to come back. But I doubt.
I can feel from your response and say, I dare you come. Anyway, let's pick up. Lady Cole Travel is asking, applying on the rules 20 years in which you need proof of being here. If you receive your letter from one address, however, stay at different places, can I still use the postal address?
So with 20-year rule, it is not where you live. It is the fact that you live in the UK.
Okay.
So whether you live in the north, south, east, west, it doesn't matter. It's even good that you can prove that you were living in the UK and at the time of your application, you are still in the UK. And that is all you need. Whether it is postal letter, hospital letter, GP record, even pay slip, P60s, you can still use them. Okay, so don't worry about changing address. You can use them for your 20-year rule or private life application, and you will succeed if it's full 20 years.
Lawyer, there's this case where this person has lived in the UK for 20 years and wants to apply on the 20-year rule. Recently, the person's bank card that he uses and the ID he uses to work has been caught up by the bank ATM, I should say, and the bank is asking that the person brings in an ID. And unfortunately, this person is using a different ID. Uh, is there any hope for this person to get their money back? What can the person do to prove to the bank that the money is his?
Right.
Your deep sigh is quite worrying.
This is what makes the law live
Right.
because you have to then, how do you represent this person if this person were to instruct you to deal with the bank on their behalf?
Mhm.
The bank is asking for proof of ID so that you get your bank card.
Yeah, and your
This
money back.
person doesn't have an ID. Mind you, it is not an offense not to have an ID. The person is living in the UK. Well, they will say that when they came, they were able to open the bank account.
Hmm.
That maybe money is going into the account. That is different story. So if I'm not able to provide proof of ID and you are not going to give it to me, if you're able to prove that or tell me that yes, we know that this is your account, then I know that the money is mine. If you decide not to keep my account anymore, you have to give back my money. That is what the rules say within the Financial um, Service Act. Now, this person can also have a choice to get an ID because they want an ID, right?
Hmm.
So the person can go get an ID. If it's passport, the person can apply for a passport from the embassy of the country where they come from or they belong, the
Hmm.
nationality of that. And so they can get an ID. It may be the case that it will take some time. So the person will tell the bank that, all right, I don't have a valid our current ID, and I'm in the process of procuring one. And since you need an ID, once that is ready, I will show you so that you can confirm and give back my card. But again, the challenge may be that this person is so much time bound to have access to the money in the account
Hmm.
for living needs. And so they will say, but I don't have time to go and get a passport. Well, if you don't get a passport, a new one, you may not even get the card to be able to access the bank account.
Right.
So either way, you are going to lose. Then take the less risk, which is spending time to get an ID so that you can go to the bank and tell them. But before that, make them aware that this is the situation. New one is being processed, and I'll get it for you. In the meantime, how will the person survive? Get friends to give you money, knowing that when everything is settled, you pay them back. And that will solve the problem.
Well, folks, you're still with us on the Community and the Law, brought to you by BWF Solicitors. We taking your comments and concerns and questions, and Lawyer Charles Asma, a resource person, is helping to deal with those. We just taking a quick break, and when we come back, we'll look at this question again. Our friend Kwesi has a situation, and we want to see if we can give him some good advice. He used an agent to apply for a certificate of sponsorship as a skilled worker in 2023. He was granted 3 years visa um, as a plumber with Yentumi Construction Limited here in the UK. In June 2024, he received a letter from the Home Office that his visa would be cancelled unless he provides an explanation of why he used a fake university certificate. Because he said he was not aware that the agent used a fake certificate. He paid an agent to take care of all the processes and only provided his passport. He says he's innocent and therefore will plead with the Home Office. So if he's pleading, what are the chances? Is it that he didn't know about the offense, so it's an innocent mistake? Is it that the agent made the application, so Akwesi is not at fault? Or are we saying that whether or not Akwesi knows that a false document was used, he is at fault because it's your application? Akwesi, we're taking a break. When we come back, we ask our friends in the classroom, our viewers, our listeners, and all people involved to help you make a decision. So stay, don't go away. Yes, we are back. So let's see how we can help our friend Akwesi. Akwesi's in trouble. Your answers on Facebook and YouTube comment section. Judea agenda is number 3. Whether or not Akwesi knows that a false document was used, he is at fault. Okay, well, Junior, let's see. Henry says because Akwesi was unaware that the agent used a fake document, he is innocent. It's an innocent mistake. Number 1, he says. Next, Emmanuel Boche, I choose 1 because he trusted the agent to be professional and to do the right thing. Ima, well, let's see. The answer is 3, Grace. Whether or not Akwesi knows that a false document was made, Susanna says also is 3 as well. Charles Amate, he is the one benefiting from the visa and should make sure all documents are real. Okay, Charles, a bit high-handed on Akwesi, but let's see what the lawyer will say. And Paul says, is the agent's responsibility? So the answer is number 2. Well, who else? Roberta Duce, Bobby says it's number 2. The agent made the application, so Akwesi is not our fault. He didn't know. He only provided his passport. Beatrice Frimpong B says number 3. Okay, let's see what else and who else has an answer. Well, with that and time not being on our side, Lasma, Akwesi is in trouble.
Right. Thank you to all those who have shared their views. So the law is clear. Number 1, it says that Akwesi didn't know about the offense. So it is the law doesn't say you know about it so you can see number 1, it's about emotion that oh he didn't know. So please, that's not the law. Number 2, agent made a mistake and so blame the agent. That's also emotional feeling. So that's not the law. Whether or not Akwesi knows that false document was used, he has to respond. That is the law. Now, so the law says that whether or not it is with the knowledge of the applicant, and if you look at paragraph 9.7.3 of part 9 of the rules, immigration rules, to be able to say you are canceling, we have to cite that bit. There is a case law, the case of Balajigari versus the Secretary of State, and this is a 2019 case where the matter went to Court of Appeal, and Court of Appeal concluded and held that before you can go ahead to do anything, you have to let the person speak and respond. And so there should be minded to cancel notice to Akwesi. Akwesi would then say that, yes, whatever has happened has happened. I agree, and I concede. However, there is no intention to deceive so that a visa could be issued to me. This is a mistake. That is nobody's fault. It is not my fault. Of course, whoever helped me might, because did not take instruction from me, didn't ask me to confirm this and that. And therefore, in your attempt to cancel or not to cancel, consider that I did not deceive. I did not intend to do anything wrong. It's just a mistake, and the mistake was innocent. And for that matter, use favorable discretion here. And if he goes through that process, the point is three, and it's likely caseworker will decide to apply the May discretion to leave him to keep his visa. The question is not whether he should be left to keep the visa or not. What will be his approach in going about this? He will use point three to deal with his response.
Well, as Laura said, paragraph 973 of the immigration rule states that entry clearance or leave that has already been granted may be cancelled where false information or documents have been provided, whether or not the applicant is aware of that. Um, However, in such cases, the Home Office must always give the applicant an opportunity to respond to those allegations, as lawyer has explained. It must serve a minded to refuse letter before any action is taken, and the case is stated there. And with that, I go over to Lawyer Charles Asma for him to give us a quick summary because we just have about a minute more to go. A quick summary of what he led us through and what he led us in discussion. Lawyer Asma.
Thank you very much. Brakoku, before we sign off, let's have this for our viewers and listeners. Let's assume that the person has not been served with minded to cancel letter or notice.
Mhm.
What would be the position of the law? Would that be error on the part of the caseworker and so a breach of the law?
Yeah, the law says that the caseworker must serve that notice to say that I am going to cancel it because of X, Y, Z. So if you have any explanation, I give you this number of days to respond, and usually it's about 14 calendar days, I guess.
Yeah. So if they don't, so what we are saying is that if anybody receives cancellation letter that your visa has been cancelled because XYZ, the
And you did not
person
receive a minded to cancel letter.
exactly the person should ask, where is the minded to cancel letter that you should have given me? You didn't give it to me, and you have concluded on the basis of that allegation. You are wrong in law because the procedure says that do A before B. And because of that, we'll go for judicial review and we will win.
Okay.
So that's that bit. So viewers and listeners, today we have been able to look at what is crucial. We've shown you an example that it's possible that after a visa is granted, you may be told that they have found something new that point to the cancellation or the need to cancel the visa. Once you receive that letter, it will tell you that you have to respond. The letter is called minded to cancel, and therefore you must act on that. If you ignore, the visa will be cancelled. Therefore, within 14 days, you respond with evidence. They will make a decision and come back. Once they are satisfied, the visa will be maintained. If not, it will be cancelled. Once it's cancelled, you'll be given right of appeal or administrative review, depending on the type of leave you have. The most important thing to consider is that the caseworker will not cancel the visa without coming to you first for information or for explanation or clarification. But it is your duty to ensure that once they do, you respond. What do you do? Whenever you are making a visa application, make sure that everything on the application form is what you are satisfied with. Again, the application supporting document should be something that you can guarantee. If not, once something is found, they will always come back. However, it is not set in stone that once they suspect that there has been use of false document or false information to get a visa, they will conclude and cancel. They will come to you for further explanation. And this is where you have to sit carefully, engage a lawyer, tell the lawyer your story, and the lawyer, knowing what to do, will work harder in your defense to ensure that what is due you is given back or maintained. This is what we have offered. Please bear in mind that we come to the platform to share knowledge and to provide information. It is not a legal advice based on which you will make a decision. Before you make a decision on the basis of the information, please seek further independent advice from a qualified lawyer. Thank you.
And thank you very much. Well, last week I served you minded to celebrate notice, and I said I was going to celebrate all birthday celebrants in the month of September. First, we had our practice manager, Madam Cynthia, who celebrated her birthday. We celebrate you again. And next, we had uh, Abigail Apiajan, a supporting staff. We celebrate you again. And our very own Na Manyete, we celebrate you again. Na, congratulations on your golden anniversary. And on that note, I want to say thank you so very much for joining us, sticking around, and having faith with us and in us to do what we do every time. May God continue to bless you. May BWF solicitors continue to live and grow and be successful so they can provide us all the opportunities as they do provide us. BWF solicitors, thank you very much from the very top to the very last person like myself, and to my studio producer, Professor Ade, for your hard work and dedication, to Sheila Ankra and Patmo Dudu for the admin and the aesthetics, and to you out there for your time. I want to invite you again. Join me for another edition, same time next week. Until then, good evening.